Hello everyone, welcome to the Sweeney Show, Business and Law podcast. My name is David Sweeney, and joining me here today is solicitor Bill Holohan. Bill, you're very welcome.
How are you?
So
Nice to be here.
you have, is it a general practice office you have in Cork and Dublin?
I have an office in Cork and Dublin, and that's a historical thing. I was a partner in a larger firm, and I set up my own firm in 1998, and I had established the Dublin branch of the office because in 1991, when we did it, I was the then unmarried partner in the practice. So I was able to spend 5 days a week in Dublin. But during a period of 91 to 98, after a whirlwind romance, Irish style, that is after 15 years, myself and my first and present wife, as I affectionately call her, got married. Then number one son arrived in 96, number two son was arriving in 98, and I said to the others in the practice, lads, I need to spend more time in Cork. And they said, well, we don't want you to do that. And I said, well, I'm going to do that. So end up was I set up my own practice, and I roughly split my time between Dublin and Cork. Now that was when you had to have a travelling filing cabinet with you every time you were going up and down. So I invested heavily in technology even back then. I investigated digital technology 22 years ago. To have the less paper office. Lawyers love paper. We're never going to have the paperless office. I went for the less paper.
And can I just take you back then to your legal training? Do you have a law undergraduate, or how did you get into law? Is it in your family?
No, I had an uncle who had no family to inherit an accountancy business, and I was very good at maths. I was straight A in maths. I was presumed, Jesus, he'll be a great accountant. And one day in fifth year in school, the English / history / Latin teacher that we had, brilliant guy, who I'm still in contact with, figured I wasn't taking notes on what he was talking about. So he circles around, comes up behind me, grabs out the piece of paper I was working on, and it was an agreement to give a loan of a book to the guy next door, that he wasn't going to bury it or whatever. And he said, Holohan, if that's what turns you on, do law. So knowing that I was kind of interested in accountancy, and then lo and behold, the 6-week course was advertised, a night course. The famous Johnny Contract, John O'Connor, professor in UCC, was going to be running the 6-week program. One night they'll do contract, another night they'll do consumer, another night they'll do constitutional. 6 by 2 hours. Got the bug, went to UCC, did my BCL there, signed up for the apprenticeship in Cork. While I was doing that, I did an LLB as well, and ended up writing a thesis on the limitation of liability under the Merchant Shipping Acts 1894 to 1981, a subject I know you're expert on, so we don't need to discuss it anymore.
We might get into that later,
I was lucky enough to get a scholarship to go to the Academy of International Law, courtesy of the Dana Corporation of Indiana. So I spent some time out there. Then, your standard newly qualified. I was lucky enough to get a job. 1983, Dunlops had closed, Ford's had closed, Ireland was in a recession, Cork was in a depression, but I was lucky enough to get a job. General practice, district court, conveyancing, bit of this, bit of that. Then in 86, I was approached to join a firm as a junior partner, where the deal was that I'd succeed after an older generation, guy in his 50s, finished out the practice. Then moved on, joined the firm where I ultimately set up the Dublin office. So I've been very lucky in the sense every few years something has come along which has kind of changed what I do. So I had a few years as a kind of a general practice, I had a few years in kind of defence litigation, I had a few years in debt collection, I had a few years in commercial litigation, and then as I described it, having spent 25 years worshipping in the satanic church of litigation, I had a conversion and I discovered the one true faith, mediation and alternative dispute resolution about 15 years ago. And I've been trying to convince people that is the way to go.
And it's certainly in the news the last couple of years. And I want to talk to you about that as well today. So, what is mediation or alternative dispute resolution?
It's an alternative to going to court. Padraig Pearse described the education system as the murder machine, but if he was alive now, he'd probably describe the litigation system as the murder machine. It's only 202 years ago believe it or not, they abolished the right of trial by battle, which is where you got the biggest bold effector you could find to go out and beat the proverbial out of the other side. And the legal theory behind it was the victor had God and right on their side. And they basically substituted trial by battle with trial by barrister. And you got the biggest, boldest barrister to go out and beat up the guy metaphorically, destroy their argument, their credibility, etc. So it's a very divisive system, and it's this destructive inquest into what happened in the past and blameworthy things. Mediation, in particular, focuses on trying to work out, look, fine, we take note of what happened, we know where we're at, but can we work on a solution that everybody can live with? And whereas if you imagine going to the round hall or in the courthouse in Washington Street in Cork to do settlement talks, you start with a shopping list, which might include a bucket of ice cream, which isn't good for you if you're lactose intolerant like me, even though I love ice cream. But you're conceding, you're giving up, and it's a negative psychological process. If you go to mediation, you're talking about, what do I need to come out of here with? And what more can I add to it? Subconsciously, it's a positive process. So there's an awful lot of psychology behind this thing. And I'm very interested in what makes people tick and what makes people thick. And unfortunately, at times in litigation, you get more of the people who are thick, whereas in mediation, you get the people who tick.
And does a mediation discussion happen the same as a settlement might, where, you know, in a normal settlement, possibly in a courthouse, one party would sit in one room with the barristers and solicitors, one in the other room, and the barristers go out in the hallway and meet. For a mediation, do you all sit in the same room, or does it happen around a round table, or how does it practically work? Or is it by correspondence?
As you know, with settlement talks, it's a game of poker. And the question is, do you know your opposite number well enough to know whether they're bluffing or not and call their bluff? And say, Jesus, David, I've been dealing with you long enough. I know you'll start off looking for double the figure. Let's get real. But if you don't know your opponent, you are playing a game of poker and a game of bluff. The great idea of mediation is that a mediator might have a group session to start with. I call it the group hug. Now, you should be careful about using expressions like that. I was giving a talk in Maynooth 2 years ago, and there was an American on the course, and I talked about how I like to start the day with a group hug, and then, you know, separate the parties into different rooms, and I'll do shuttle diplomacy between them. And at coffee, she came up and said, "Can I ask you a question? You Irish, you're so friendly, but how do people in conflict handle being asked to hug each other at the start of the day?" So you do generally get people together at the start of the day. You set out the ground rules, but it's shuttle diplomacy. Now, the mediator is a bit like Humpty Dumpty sitting on the wall, but with legs long enough not to fall off. And you have the advantage of seeing into both rooms. Now, the whole thing is confidential, but even within that, if you remember your junior certificate maths, I did the intro, you probably did the junior. There are subsets within that of confidentiality, and nothing that's in one room gets revealed to the other room without express permission. But you can go into a room and the client can be there and say to you as the mediator, "Look, I don't want the other side to know this, but I'm a busted flush. I can't actually afford the costs of getting in the door of the court. Or I'm dying, I have a terminal illness, I'm not going to be here, and, you know, I want to secure something for my family," or whatever. And they're dramatic kind of reasons. But once you know the full story and you know what's actually driving people, sometimes it's not really what the pleadings tell the story is. Something different can come out. And I can give you a very quick example. 2 brothers, very successful business, 15-year gap. Older guy was the finder, the guy who went out, brought in the business. Younger guy, very intellectual, tending towards the spectrum, maths, figures, the whole lot. Younger guy suddenly announces in his early 40s, he wants to sell up and move to America. The older guy says, "Hang on a second, we have another 20 years of growth in this business. We've been on a growth path." And memos backwards and forwards. The younger brother, the analytical guy, 15-page memos and spreadsheets. The older guy, Albert Reynolds style, 1-pager. About to go to court to wind up the company. I mediated with another guy, and the younger brother revealed to me in confidence that the reality of what was driving this was he had married in his 30s. Himself and his wife had gone through IVF unsuccessfully. Being very, very rational, he thought, if I go through a 6-year assessment with TUSLA and Board of Tala, the adoption board, to get approval, I'm going to be in my late 40s, and there may not be any kids available. If he moved to the States, within 2 years, the NSA having lived with them for 2 years and investigated everything, they'd have a child in the house. So the older brother, he couldn't tell his older brother that. He was in so awe of his brother. But he got me to reveal it. The older brother said, of course, we can do a workout. So what they did was they sold some properties owned by the company, generated a cash pot. Your man cashed in some shares, went off to the States, very successful business there, stayed involved in the business as a non-exec director and shareholder. And 5 years after that mediation, they sold the business for 5 times the value of the business at the time of the mediation. Whereas if they'd gone to court, fire sale, reduced value. So mediation can add value in those kind of
just by
circumstances.
even open
and
communication.
it can unlock what's really driving people. Is it recognition? Is it an apology? Is it really the money that they want? If someone feels they've been defamed, is just the apology, the recognition that what was said about them was not true? Is that all that will take it to resolve it? Sorry, I've been rambling on.
No, that's perfect. And can I just ask you there, two of the main kind of, I suppose, hitting points for mediation in comparison with going through the court process is costs and time. What is the comparable financial cost to go through the mediation? And where on it does it fit in the timeline and comparable to like a circuit court case or a high court case?
Okay, you can mediate at any stage, before, during, or even after proceedings if it comes to that. But the cost savings are huge because your standard, simple, straightforward high court action, if it came to it, you're looking at almost 50 grand to get to the point where counsel stands up on his feet to say, I appear for the plaintiff. Circuit court, again, depending on the complexity of the case, it could be 10 grand plus. If you're going to mediate, you've obviously got the party's own costs, which are a separate issue. But if you go and try and get a senior counsel to mediate, they're going to look for a senior counsel brief fee. There are plenty of solicitor colleagues who will mediate, and you're talking about a couple of grand per day as a cost for a mediator to do the reading in beforehand and to mediate on the day. Once you're clear what the issues are, you can mediate very early and you can save all around. The difficulty is that a lot of lawyers operate on the principle that they need the big case with the big fees that results as a result of a hearing that goes through taxation to come in and bump up the annual figures. They don't realise that if you can become known as, geez, David Sweeney is the man to go to, he can get an outcome for me in 6 weeks' time, 6 years' time after litigation. You become the most popular man in town. And you can bill on the gratitude curve more handsomely, proportionately per hour, than for all the time that would go into a litigation case. So ADR does not stand for alarming drop in revenues. It is.
And I suppose even if you break down the resources in the office that you have to put into running a case through court, through maybe anywhere from a 2 to 4 year process, where mediation you can resolve possibly in a number of months.
Yeah. But it's all down to the question of once it's clear what the actual issues are. Now, you may need pleadings to tie that up. You know yourself, sometimes you can read pleadings and not be entirely clear what the actual issues in the case are.
And how does someone, because I know you are an accredited mediator, how does someone become a qualified mediator? What's the process there? Is it an independent body?
You're not an accredited mediator yet?
No.
Okay. You are now accredited by the Church of Bill. Okay. Unfortunately, there is no kind of standard in terms of a public regulated system. Anybody can call themselves an accredited mediator. The question is, by whom have they been accredited? So you can go out after the podcast and say, I'm an accredited mediator accredited by the Church of Bill. But what value will people place on that? And the Act now requires people to disclose their qualifications. There are a number of different institutions. The Chartered Institute of Arbitrators, of which I'm a past chair, for example, accredits mediators. The Mediators Institute of Ireland do it. CEDR, the Centre for Effective Dispute Resolution. Friary Law. So there's a number of different bodies. Now, they have a slight different emphasis. Some would be more inclined towards the kind of the family law end, the soft end, so to speak, elder mediation, family mediation. CEDR would be more towards the commercial end. The Chartered Institute would traditionally have more kind of a construction bias in their terms of membership. So we'll be more towards the kind of the property dispute resolution. But I'm accredited by all three of the primary ones, the Chartered Institute, the Mediators Institute, and CEDR.
And how much of court work do you see now, or potential court work, moving to the mediation process? Is there starting to become a shift towards it?
Well, 2 years ago, when the Act came online and the rules became available, I sent the rules around to every office in the country, because they weren't generally available. And I offered to do CPD. And between February and June, I did 32 CPD sessions pro bono with contributions to charity instead of the speaker's fee. But it was a very hard sell because people weren't convinced. They didn't really understand how it would work, and they couldn't see the value offering. But the current pandemic and the announcement only yesterday by the Chief Justice that following health advice, court resources are going to be now very limited, that you're only going to have courts sitting for about 2 hours a day. That's a game changer. If people now want to get resolution, they're going to have to think about arbitration, which is a private judge. They're going to think about adjudication, which is where somebody judges, but you're going to talk about expert opinions or expert determination. You can have mediation, which is where the parties decide the outcome, but with the assistance of the mediator. Conciliation, which is mediation plus, which is where if you can't get them to agree, they might say, look, David, you're a sound fella. You know, you're rocket sense, you've played down the middle. Can you give us a recommendation? We agreed beforehand that the recommendation is either binding or non-binding. So they're all the various options. But if lawyers want to get fees in, it's going to be results-based in the main. Not everybody can bill on the hourly basis and get paid on the hourly basis. So there's milestone billing when you've achieved something for the client. In order to achieve something, you're going to have to look at other ways of achieving an outcome or result.
And you see, just the topic you brought up there about court procedures, and I know they are suggesting 2 hours limit per court and maybe looked at across all employment places of work over the next couple of weeks. But we got a missive in from the circuit court of how you actually approach court, and there's a number of things that just aren't going to make court practical. You can't pass documents up now to the judge through the county registrar. There's to be no settlement negotiation. So your barristers, if they wanted, they can't now approach each other. I know you sent out an article, I think it was the last week or maybe two weeks ago, about how solicitors' office should cope now with bringing their businesses online or coping with COVID-19. What are your thoughts on all that, or how should, as a legal business, should we be prepared or be working towards the future with COVID-19?
Well, I think, the COVID and what we're doing now, having a Zoom conversation, is a game changer. If you had suggested 3 months ago to somebody we'll have a Zoom meeting, that it come out with the eponymous what, they wouldn't have understood. But this is as effective as a face-to-face meeting, and cuts out all the travel time. It cuts out a lot of the messing about. There's no reason why this can't be done online and done securely. The problem with the courts is that access is going to be restricted. Last week, I had an injunction application in the High Court, and everything had to be prepared in advance, uploaded. So the judge was looking at it, not in hard copy, which you normally do by handing up a big bundle of papers. It had to be in beforehand so that they could read it. They'd gone through it the evening before so that they were prepared on the morning to go through it. There was an agreed paginated bundle, and that had to be all agreed beforehand, so that when someone said page 49 of the book, everybody's literally on the same page. All of that is changing how it's done. Starting with the Supreme Court, they've started having cases heard where the judge is sitting at home, the registrar is sitting in court, and the counsel, solicitors, etc., are all sitting in their respective homes as well. And that's going to filter down. But if you think about it, the district court, where you can have a black hole at Calcutta experience with hundreds waiting, something as simple as parking fines. There's no reason why it couldn't be done on the basis of a queuing system where people log in and they're admitted for the purpose of their hearing. They're at home. They don't have to waste a day. They can take simply an hour out if it took that long even to log in.
I think there's probably though a question of the courts system or the courts offices, the investment in the infrastructure of the technology there. It's maybe not there yet to do that across the whole of the country.
Yeah. Brendan Ryan retired as the CEO of the court service last year, and he was a contemporary of mine in Springnabe and Bishopstown many years ago. He was a year or two ahead of me. But he, for years, was trying to get investment in systems because some of the court service systems were back as far as Windows 95. The technology just wasn't there. But, of course, over the period of the bust from 2008 onward, the money wasn't there. They poured millions into courthouses but not necessarily
The physical
the
brief for
electronic.
it, yeah.
There's the base on which the technology can be built, but that's fine. But it's going to require a massive investment.
And it sounds like the biggest shift is in mindset, really, isn't it?
It is. It's just a new way of doing things. And if someone had suggested, as I say, months ago, that meetings would take place in this format, it wouldn't have considered. Now, I've had arbitrations where I, as arbitrator, have sat and received video evidence from Singapore. A lawyer late in the evening in Singapore stays on in his office and logs in to give video evidence. It can be done. Now, Flor McCarthy, who you had on recently, has started a campaign about oaths and defamation. Again, in that scenario, we had to deal with it on the basis this was not a Christian who was in Singapore. So he simply affirmed that all the evidence would be true. And again, we're going to have to get to that in terms of how we'd handle online systems as well.
Can I just ask you there as well? You wrote a really good article. I'd say it might have been a month ago. I think it went out in Dublin about the term without prejudice. It's a really interesting part of the legal process where, I suppose if anyone is not unsure of what is when people use the term without prejudice on a letter, why do they do it and where is it used?
Okay, unfortunately, it's used too much and not in the correct way. People will send you a letter saying, I got your letter and I'm acknowledging receipt without prejudice. That's meaningless. Now, in order to get things done, again, whether it's through correspondence or whatever, you might want to make a concession and say, look, my client was backing out of his garage. The hazard's on, clearly visible, but your guy tried to squeeze past because he was in a rush. But my guy is coming out of the garage. He was the one backing out. It wasn't his fault, but he will be held responsible. So I'll talk to you, okay? And without prejudice, I'll accept that we will pay something. And you say that, but that can't be held against you. If you don't do a deal and settle on it, you can go into court and say, well, Judge, my client will give you evidence. He was backing out. He has a camera on the back of the car. He could clearly see the car was coming. It stopped. He continued backing out. Your man suddenly decided to keep going and try and squeeze past, and that's how the accident happened. So it allows you to make an offer, a concession, to try and compromise proceedings without it ever being referred to. Off the record would be the layman's way of referring to it. So you can do that and admit something, make an offer without prejudice, and if it's not accepted, the record doesn't disclose that. That's the real meaning of it.
So how did it come to pass so that solicitors and legal practitioners have, without prejudice, nearly on every piece of correspondence that you send out in litigation?
Because lawyers love jargon, and they just fall into using jargon all over the place. Another example would be to revert. Lawyers love to say, I have your letter, I will revert to you. Now, my English teacher that I referred to earlier would, kill people for doing something like that. Revert means to go back to a former position or state of being or condition. So I can never revert to being to you because I never was you, and you can never revert to me because you never were me. So these phrases creep in.
Yeah.
And people...
Sorry, Bill, something happened with the microphone there. Hello? Something happened there with the sound. Can you hear me now?
I can hear you. I can hear you.
Sorry, got you there now. Yeah, sorry, Bill, yeah.
What I was saying was, if you were to say to somebody, that's an ignorant statement, they would think you're attacking them personally, that you're calling them, in some way mentally deficient. But the true meaning of that statement is made without knowledge of all relevant facts. In other words, in ignorance of relevant facts. But that's not the way people interpret language.
Yeah.
That's why you've got to be so careful about the way you express things.
And can I just, in your article as well, there was two things that kind of jumped out. Is that one is that you can have without prejudice on the letter, but doesn't necessarily mean it's not going to be an open correspondence. And the alternate is that sometimes you may not put it without prejudice on your correspondence, but if it was part of a chain of without prejudice correspondence, you just didn't put it on that one, it can still be held as being without prejudice to you.
Yes. give you an example. I had this ongoing battle, which is what actually prompted me to write the article, with a firm of solicitors, where I offered to mediate. And they wrote back saying, without prejudice, we don't want to mediate. We want to do simple negotiations. Now, the difference with mediation is that you get to eyeball the other side on a one-to-one basis, at least at the very outset. And in this particular case, we wanted to explain to the plaintiff in the case exactly why the case was being defended and why we were saying there was no defence. Because with no disrespect to the colleague, we're not satisfied that that message is getting through to the client. And we wanted the opportunity to put it directly. They keep replying saying, without prejudice, we will meet for settlement talks. And I keep pointing out to them, you're not making any concession. You're not offering anything. That is not a without prejudice offer. In fact, it falls to be treated as open correspondence. And I'm telling you now that if it comes to it, this correspondence will be revealed. And I didn't think that they actually understood what I was talking about. Equally, you might start off an exchange saying, look, without prejudice, we're prepared to compromise on the amount that we're looking for. We're prepared to take smaller money for a quick resolution. And then there might be an exchange going backwards and forwards, which doesn't actually have the magic without prejudice tag on it. But if it all is part of a chain where it's clearly starting as without prejudice, then the protection of without prejudice can continue through the chain.
Bill, listen, thank you so much for your time today. That's been really interesting. I just have maybe two last questions for you. What's the future for yourself and for the firm, short term and long term?
I think everybody's going to have to look at their resources, the staff structures, their cost structures, etc. I think there is going to be a downturn in business. There might be an upturn. I've got 5 or 6 items in relation to business interruption insurance claims on my desk. It'll change in terms of the demand, but there's anecdotal evidence at the moment that conveyancing, for example, is likely to take a huge dip. That even existing loan sanctions are being pulled on people. So I think everybody's going to have to be conservative and look at how they can do things faster, cheaper, and better. And if that means that you invest in digital technology and you rely on that and not necessarily a secretary, that you don't necessarily have an office space, you have a virtual office space, that you combine with other colleagues in the one building where you have a common reception, common resources, common ordering of materials for the building. They're all things that people are going to have to look at. No comfort can be assumed, I think, in the way things are going. I've lived through a couple of recessions now at this stage. I qualified in a recession. I've come through the last recession. Cyclically, my economics teacher from secondary school would say that traditionally it was, 7 year up, 7 year down, and government interference would make it higher or lower over time. You just plan as best you can, but you have to have a plan. If you fail to plan, then you're going to plan to fail. Yeah, and then, well, hopefully on a more positive note, if there was any young solicitors, young law graduates out there at the moment, what advice would you give them? Would you recommend law as a career? Oh, yes. Only last week I got a gift from somebody that I spoke to last year who had done his law degree, done a master's, went into the first bar entrance exams, and he figured he made an absolute nibs of it. And he was a friend of a son of mine, and he came up for a chat, and I gave him an hour. And I said, Billy Fitzgerald, the first Chief Justice, failed his bar exams. You're talking about the next 40 weeks of your life, not the next 40 years. It's only a minor setback. And I actually suggested that he might look at a judicial assistance position, which was being advertised at the time. And he actually did that. And the reason he came back with a large bottle of expensive whiskey to me last week was because he said, it was a brilliant year. I got to see a variety of different types of cases, courts, how people work, what works in terms of trying to pitch a thing across in court. It's very varied. I would say to any young lawyer, try and get a general experience before you specialize. Ideally, specialize afterwards, but be able to understand everything. Don't become an expert in the law of the left big toe without knowing what the law of the right big toe is all about. Forget the minutiae, but you need to have an understanding of things generally, and hopefully a love of the law, because that's what's kept me going. And I've had a couple of highs. Like when I started the week, when I was splitting from my former practice, I actually did a Supreme Court case myself, and they can put this on my tombstone. I successfully persuaded Baron, Murphy and Flaherty, 3 judges in the Supreme Court, that a seat in law in Ireland, in a theatre or place of public entertainment, is not a structure on which you place your backside in a sedentary position. I'm paraphrasing slightly with the way I put it. It's the airspace you occupy from the moment you enter a building to the moment you leave. Now, if somebody's really interested and anally retentive, they can contact me to find out the why of that. But, you know, the law is fascinating. It's engaging. You're problem solving. There's, as my old headmaster used to say, new things every day.
Yeah.
And if you can approach it with that mind, you'll have a great life.
Well, Bill, listen, thank you very much. That was certainly a fascinating, interesting conversation. We thank you so much for your time, and we sincerely wish you all the very best for the future.
Take care.
Thank you.